And welcome back after a short break. This is the part two of the IP law and cognitive sciences. Now, we ended, we finished the second part with a short reminder, with a conclusion that the intellectual property law, sorry for that, that the intellectual property law is, first of all, governed by several international agreements, mostly illustrated on the example of copyright law. And secondly, with my small and quite limited reminder of what are basic paradigms of intellectual property law, on the example as well, a copyright law, meaning that the intellectual property law is based on protection over a result, intellectual or investment or financial efforts undertaken by a producer. And in the example of copyright law, we think and we focus on intellectual engagement that is, the result of intellectual engagement that is or shall be protected under copyright law. The second paradigm was the question of intellectual, incorporeal, intangible effort that's supposed to be the subject matter of intellectual property law. The third was the perceptible, or the question of the perception as perception by mind, by sides of senses of sight and hearing that were constitutive elements of identification of subject matter. And last but not least, that's actually the consequence of how the intellectual property subject matter is constituted, the monopoly rights, meaning the exclusiveness that is granted to the right owner due to the fact of intangible nature of the subject matter. Now, these are the paradigms that were actually established in 19th century in the Berne Convention. Now they functioned, they have functioned or have been functioning already. That's the third century, and they were challenged by digital technologies, mostly due to the fact that the rapid spread of digital environment, social media, internet piracy, etc. We were quite or the legal order was quite challenged by digital technologies and how the technology was actually evolving, mostly due to the fact that the social media actually reverted the question of what shall be protected and why shall it be protected, as not the question over the intellectual effort, due to the fact we leave likes and dislikes and comment on several photographs of Instagram, which means that there might not be as much intellectual effort left over the internet. However, the privacy of users is of great economic value nowadays. So that's reverted the question of what shall be protected. Now, also the question of how to change the intellectual property law or the international provisions of intellectual property law, if it is governed by several international organizations and treaties. And the technological development is changing rapidly, actually constantly in our eyes. So the unfitness of intellectual property law is an obvious or even truistic statement. Nevertheless, what I would like to do with you during the second part of our meeting, or my talk, is to show you that's not only technological development, but also development within the research of cognitive sciences challenges the questions stated or posed by the intellectual property law, or actually how the intellectual property law is constructed. Now, we start. Due to the time limit, I will focus on two major problems of intellectual property law that were challenged by the cognitive sciences. The first one is the artifactuality, which also means the subjectivity of judicial decision over subject matter of copyright law. I will just illustrate it on the example of copyright law. The artifactuality, I mean, under the term of artifactuality, I mean the result that's supposed to be protected under copyright law. I mentioned earlier during the first part of the recording that only the result shall be the subject matter of a normative protection, not the process or the performance itself. We have several different legal orders that may, or legal provisions, institutions that may protect also the performance, at least the artistic performance. But I think about the result as a constant constant artifact that we may be able to identify as a wholeness as a result of intellectual effort. And this paradigm of artifactuality, due to intellectuality or intangible nature, um, implies the subjectivity or relativity of judgmental decision over its status, legal status. That is what the cognitive sciences are actually claiming nowadays. And the second major problem identified within the cognitive sciences are the dichotomous solutions used within the legal order of intellectual property law. And here I need to um, um, tell you or show you a few words about the idea expression dichotomy in copyright law. Idea expression dichotomy means that only the expressions, so how the words are manifested, or what choices of words were used by author, this kind of expression is protected, and not the idea that is behind it, so that the idea remains free as the air and no one can monopolize it. That's the basic thing, basic thoughts behind the legal order of copyright law. And this kind of dichotomy logically is already problematic due to the fact it's not always possible to distinguish between idea and the expression, and obviously there are no expressions without any ideas behind it, at least I believe so. So at least at the conceptual level, the idea expression dichotomy is already problematic, and I will show you why it is also additionally problematic due to the cognitive sciences. Now, let's start with the first problem, the artifactuality. Now, I mentioned earlier that the copyright subject matter operate with a vague notion of originality. We've probably heard about it and used to talk about it, discuss it with your friends. The originality may have different meanings depending on what kind of jurisdiction you are currently within. For example, within the continental Europe's countries, originality supposed to mean, or was interpreted by the Court of Justice of the European Union, as as authors' own intellectual creation. Whereas several years ago, under the Commonwealth system and within the US UK system, it was mostly associated with efforts that were undertaken in order to create a new work, a new product, like Sweet of the Brow, that was also called a doctrine of the Sweet of the Brow. Now, originality operate alone is a vague notion, and within cognitive sciences, there were academic psychologists specializing in creativity research, identified in 1960s when AI was a new field, and he investigated artificial intelligence, the creativity, the notion of creativity and originality. He identified 50 different definitions of creativity and originality alone, cataloged them in order to, with respect to different sources. So it shows how vague notions are firstly associated or incorporated within the legal system. Even just from the start, you see that it might be quite difficult to incorporate only one and unified front in order to create a stable line of judgments. respectively of what kind of work is under dispute. Now, I also mentioned to you that the second paradigm of copyright law is based on assumption that only the visual or hearing perception of a work is suitable for copyright protection. Now, neuroscience shows, and that's not obviously cognitive science, but neuroscience shows that the visual perception is an act that cannot be separated from the interpretation. So, copyright law is based on a paradigm was supposed to identify the subject matter without any qualitative or quantitative evaluation of it. So it's supposed to be just sorry. It's supposed to be only identification and not the evaluation alone. Now, the neurosciences and cognitive sciences show that we cannot separate the act of identification from the act of interpretation whenever it refers to the intellectual perception. So the mere fact that the subject matter of copyright law is perceptible or should be perceptible by mind means already that the objective identification of it is not possible. Now, other studies show that the recipient's aesthetic prejudgment is quite important for the evaluation of work, also meaning the evaluation of work. Now, I mean, there is a disclaimer to be expressed right now that not every work of art is obviously considered to be protected under copyright law, as well as not every copyright subject matter shall be considered as a work of art. But the mechanisms and how our brain works is quite an important thing, irrespectively of whether we speak about the work of art, we're supposed to also refer to our intellectual engagement, or whenever we speak about copyright subject matter that might be, for example, the iPhone model, or the model of a cup, or I don't know, the work written or drawn by a work written by a child. So as you can see, the same neural mechanisms might be working or applied whenever we speak about work of art and the copyright subject matter due to the intellectual engagement that's supposed to be applied. The examinations that were performed in order to investigate how our brain works and how we identify works of art might be also applicable, at least at this discussion level, to the copyright law. Now, the study shows that whenever also the study shows that whenever it is possible to distinguish neural activity caused by interaction with a work of art. However, first of all, it has not been sufficiently demonstrated whether these reactions are not caused by information provided to the recipient and that they are experiencing a work of art and not as an ordinary utility item. That's quite an interesting thing because it shows, and that were investigation performed by Tinio and Laser in 2018, and all the sciences in neurosciences, that the more information that is provided before the subject is experiencing a work of art, the more possible is for him or her to admit that the work is original and creative. That's also a subjective or description that we use, a notion that we use in order to investigate whether a work is protecting the copyright law. For example, the examination was performed with respect to postmodernistic work of art, and whether there was a title, long descriptive title in the art gallery manifested or expressed somehow, it was more possible for the subjects to admit their works, these works are original. Now, if we transpose this kind of thinking and line of argument to the copyright law, we might argue that the more descriptive is the lawsuit that something is protected under copyright law and something is not, there is a more possibility for a judge to admit that the work is protected under copyright law, and therefore there is an infringement, and that there was infringement the infringement occurred. So both the previous experience, the descriptiveness, also the prejudgment on our alone tastes, personal taste and experiences with the works of art, and what we consider to be beautiful, what we consider to be original. These are the elements that influence our choice of originality and creativity. Other studies showed that the more experienced were the people who were investigating or examining works of art with regards to originality and creativity, the higher threshold of the originality and creativity was performed. Now, consider one of most important accusations against copyright law, that the threshold of originality required by judges within the line of judgments, irrespectively of jurisdiction, is the low threshold of originality, probably due to the fact that most of the lawsuits are not associated with higher art, but associated with utility items, just like the project of a knife or taste of a cheese, or I don't know, a most recent judgment from the Polish jurisprudence was with regards to a phrase from a popular song. So as you can see, problem is the person who is actually deciding and identifying the subject matter of copyright law, there's opinion, pre-aesthetic experience with works of art or utility works, and also how the lawsuit is how much descriptiveness is implied within the description of subject matter of a dispute. It all leads to the accusation of subjectivity. No actually possibility, at least at this neural level, to distinguish between the identification and interpretation, therefore evaluation of a work, and no one tends, and no legal order tends to no legal order tends to have a subjective opinion of judges incorporated within the legal framework. Now, the second question, or the second problem identified earlier, was the dichotomy of copyright law. Now, as mentioned, I used the example of the idea expression dichotomy. At least at this conceptual level, it might be already problematic due to the fact there are no expressions with ideas behind it. Nevertheless, copyright lawyers use and quite often use it as an example to illustrate why copyright law is important, and why we cannot, however, protect ideas under copyright law. But even if we agree that some kind of limitation should be applied within the copyright law, and we agree over the paradigm of idea expression dichotomy, it might be quite difficult whenever we think about facts that might be original, in a sense that, for example, they are infused with opinions. Consider medical diagnosis of a cancer. It is quite important how it was made. It is quite important whether a physicist got enough experience, sufficient experience in order to state this kind of diagnosis. It is totally different, at least from at this intellectual level, from the weather prognosis or weather forecast. So what is the weather currently, and what would be the forecast for the weather for next several days? There are different levels of intellectual engagement incorporated within this kind of facts or information or ideas behind it. As you can see, we cannot simply agree over what constitutes an idea. And even if we agree what constitutes an idea, a mere idea, typical fact, or typical information, there are different types of it, and not every type we wish to have. We wish to have to have outside the legal order, so not protecting the copyright law, at least some of the owners or right holders. Other questions remain. Another question was posed by several copyright scholars with regards to the fictional facts, that just like in the example, who is the Batman, or the spoilers from the most important series or of movies, etc., and so forth. These are also the information that may have quite important economic or cultural value for the people, some people. And therefore, the question remains whether they're supposed not to be protected or supposed to be protected or not. Even if we consider, especially if we consider that some part of protection, normative protection over information, is already incorporated within a legal order. It is the protection of the know-how. Therefore, the question remains what and how to. Where is the limitation, or what is the difference between the idea and the expression that's supposed to be protected? Also, and I haven't mentioned it earlier, but it's also quite important, especially considering cognitive sciences. Copyright law operates with a notion or paradigm that something was created by author himself or herself. So, like a person who is not inspired by other people, who does not incorporate something cultural or scientific values or data information from other people. Um, to put it simply, a person who is under radical lockdown without any possibility to connect to other people. That's a notion of an author who is a central piece to the copyright legal system. So, a person without any cultural network. And obviously, whenever you think about author within the cognitive sciences, you might think as a person who is entangled within the web of cognitive or social interconnections, etc., and so forth. So think about the term of intertextuality that was already introduced by Julia Kristeva, meaning a way or holistic network of interconnections between works and artifacts and culture goods. That is how our culture and society works, and therefore the author shall not be considered as an isolated person or isolated island over the um, um, whatever he or she creates is also a part of cultural heritage and societal that he or she finds himself and hence herself. So the cognitive sciences also tends to focus and challenge this paradigm of copyright law, and the question remains how to solve this puzzle. Shall we change the IP law, the copyright law in general, or even abandon the principle of intellectual property law? Probably. Some of you probably agree with this question or tend to answer it positively. Or shall we recalibrate its notions? And that's how I would suggest to answer, mostly due to the fact that all the international provisions and organizations are quite difficult to change, to amend, and to provide new legal orders. Nevertheless, probably that will be the question for the future, and that will be probably question for the future, and how and without this kind of discussion, or without thinking or recalibrating the system nowadays, we will stay within within the legal order that remains unfit, and that do does not would not address our needs as societal needs and tendencies. So to put it quite simply, to put it quite simple, IP law and cognitive science does not actually go hand by hand, and not only technological development and digital environment challenge the system, it's also the front from the cognitive sciences and neuroaesthetics and neurosciences as well. So probably there is a quite urgent question of recalibration of the system, or the interpretation of its notions and paradigms. Hopefully it will happen sooner than later, and probably also due to the fact that the digital technology and artificial intelligence is already knocking on the door and challenging and reverting some of the questions. So most important thing is to stay tuned and to think about what we would like to protect, or what would we like to that's supposed to remain within the system, and or within the legal order as such. So thank you. Yeah, it is also additional literature I would like I would like to recommend for you. One of them is my book, but the second is also quite interesting book by and research done by Justine Pilar from the Oxford University. So I would like you for you to recommend. I would like to recommend both of the books for you to at least confront some of the questions posed today. And whenever you have any questions, I would like to discuss some of the issues I mentioned today during this rapid and quite simple and limited recording. There is my email address, and feel free to contact me as well. Thank you very much, and yeah, thank you for watching.